Thank you. Welcome to the John Marshall Law School and another outstanding conference in the series on the law and the media, put together again by my good friend and colleague, Professor Michael Polelle. The Law and the Media Conference series was originated by Professor Polelle about 8 years ago. It illustrates the multifaceted skills and talent of Professor Polelle and reflects upon the goals of the law school. People will be telling you all about the school and the conference and that, but Professor Polelle, who is very unassuming, won't tell you about himself. So I'm going to take the liberty of doing so and ask your indulgence. Professor Polelle is a frequent person to be interviewed by the media on a wide range of topics. He is a regular reporter at the judicial conferences in Illinois and elsewhere, and talks on, again, a wide range of topics, including something many of you who are not lawyers might find not too exciting, but always brings a rush of some sort of emotion to lawyers, the topic being legal malpractice. He has also put together a series of conferences on Italian trade law and economics, which he is running this semester. In addition to that, he has been in the University of Maastricht Law School in the Czech Republic, talking on free speech. That's a reflection of the lustration laws of the Czech Republic, which is similar to the old loyalty oath of the days of Joseph McCarthy, which seemed to need some airing while we were there. I think today's conference raises some very interesting, not incidentally, but parenthetically, I note that one of the other panelists from that conference on free speech is present today, and that's Bernard Judd from the Chicago Daily Law Bulletin, who was there to make sure we lawyers who were there did not claim all the credit for protecting free speech and that the media got their proper coverage at that conference. But today's conference is very, very clearly defined, and that is the ability of a public figure to get a fair trial. And with today's media, it becomes a matter of grave concern to some of us. And I think there are several distinctions which I'm sure will be made along the way, but the O.J. Simpson trial presented several facets of publicity and fair trial that I think were beyond the wildest dreams or thoughts of any of us in the past. We had been familiar with several trials more recently that were similar, but hardly of the same ilk. The Smith trial in Florida, which for some reason did not gain the popularity that some of the others did, or the Tyson trial in Indiana, which also did not seem to gain as much coverage as the trial of O.J. Simpson. The Simpson trial, I think, illustrates that this was basically a trial that didn't involve a political figure such as that of Attorney General Mitchell in the past and of some other political figures such as Oliver North, which adds a different dimension. I think the O.J. trial was basically one in which it was entirely something that would not have gotten a lot of coverage if it had not involved a rather major figure. And except for race, that is it. And it seems to me that the question of race played out as a matter of strategy in the courtroom and a matter of response from diverse segments of the community as the verdict came in. So to that extent, I think it was a very straightforward issue, I should say, that was that will be presented by this particular conference. And as far as the race issue is concerned, I thought long and hard as to how that might impact above and beyond the public figure issue. And I would suggest that if Arnold Palmer or if Frank Gifford were to have been involved in a rather lurid, spectacular trial such as O.J. Simpson was, we would then see the question as it was properly presented. And I think the same publicity problems would have been there without the race issue. So I just, with those few thoughts, I would simply say I hope you are all here to enjoy yourselves as well as to learn, because that's one of our mottos. You, at the John Marshall Law School, you shall have fun whether you want to or not. And so, without more ado, let me introduce as I said, my good friend and colleague, Michael Polelle, who will take over from here. And thank you so much for coming.
Thank you, Dean Johnson. And does that mean I get my new office? Thank you very much. The conference, which we've now renamed a symposium in honor, I think, of some of the topics that we've been considering, very serious topics, is funded and has been for the last 8 years by a grant from the law firm of Baker McKenzie to promote the understanding of two beleaguered professions, law and journalism. During the OJ trial, the American Bar Association did a poll and found that 41% of those interviewed had less respect for defense lawyers based on what they saw. 56% thought less of the media as a result of what they saw. Even the founding fathers were not above lawyer bashing or journalist bashing. Ben Franklin said, "God works wonders now and then. Behold a lawyer, an honest man." Thomas Jefferson, in one of his darkroom moments, said, "Advertisements are the only truth to be relied on in a newspaper." No wonder, then, that high-profile cases like OJ rivet national attention. They bring together the two professions that the public most loves to hate. The First Amendment has been expanded since the 1970s. The Supreme Court in 1976 in Nebraska Press said that normally no gag order may ever be imposed on a journalist reporting a criminal trial. In 1980 in Richmond News, the Supreme Court said, even if the prosecution and the defense agree, reporters cannot be locked out of a criminal trial. A year later in Chandler versus Florida, the Supreme Court said, nothing in the United States Constitution, not even the Sixth Amendment, automatically prevents cameras in the courtroom. In 1976, there were only 3 states with cameras in the courtroom. By the time of Chandler, there are 31 states that allowed cameras in one form or another in the courtroom. This has meant increasing conflict between the rights of the press under the First Amendment and the rights of a defendant to a fair and impartial trial under the Sixth Amendment. The classic theory of Oliver Wendell Holmes, stated in Patterson versus Ohio, is, quote, "The theory of our system is that conclusions reached in a case will be induced only by evidence and argument in open court, and not by any outside influence, whether of private talk or public print." In the Sam Shepard case in the 1950s, Dr. Sam Shepard was convicted for the bludgeon murder of his pregnant wife in their Cleveland suburban home. In reversing, the U.S. Supreme Court said the trial was a carnival atmosphere, that circulation-conscious editors catered to the insatiable interest of the American public. Murder, mystery, sex, and suspense were combined to intrigue and captivate the public fancy to a degree unparalleled in recent annals. Well, those annals have been paralleled with the OJ case. There were over 1,000 media correspondents accredited to cover that case. There were 250 phones installed in the courthouse. There were over 10,000 stories written in major newspapers about the OJ case. And according to U.S. News and World Report, it was a leading network story in 1995, with Bosnia a distant second, Oklahoma bombing third, and the U.S. budget fourth. The fallout goes on. In Illinois, we have a bill now to ban jury consultants from sitting in the courtroom. I think a direct result of the OJ trial. It was inevitable, therefore, that our Law and Media Committee would consider this topic, whether a public figure can get a fair trial in the media age. That was before we knew the verdict. Now we might reword it to say, can either side get a fair trial in the media age? Professor Doris Long of our committee will now introduce our distinguished speakers.
It's both my privilege and my pleasure to introduce our speakers today, although I have to be honest that like many of you in the room, I spent most of last year watching them, so I feel like we're already old friends. The first person that, because we're talking about the media age and public figures, I think each of our speakers has a unique combination of experiences that gives them an insight into this process. Each of them are trained litigators. They've had lengthy courtroom experience. They also have the insider's view of the media because they have served as commentators for CNN and on other broadcast programs in connection with media events and with legal events and with commenting on trials and different issues that arise. Our first speaker, Greta Van Susteren, has had an extensive experience as both a litigator, as a teacher, and also as a media consultant on legal affairs. She is no stranger to high-profile media cases. She graduated from Georgetown Law School, and since that time has represented numerous clients in various cases as diverse as murder trials, First Amendment cases, patent litigation. She's been involved in some high-profile, high-media-type cases in connection with representing issues concerning abscam prosecutions and airline crashes. She's also served as an adjunct professor at Georgetown Law School, so she has brought her skills into the classroom as well to try and train new lawyers coming up. She's probably most well known to us as a result of her work as a commentator for CNN and on other broadcasts in connection with numerous courtrooms. In particular, among the ones that she's watched, we've watched her daily, on a daily basis, as she commented on certain prominent trials that were covered by CNN, including the child divorce trial, which was down in Florida, including the William Kennedy Rape-Smith trial, and also, and most recently, in connection with the O.J. Simpson trial. And since CNN and Court TV were the only two that covered the Simpson trial on a daily basis, the other broadcast networks didn't cover them, we had the opportunity to see both Greta Van Susteren and Roger Cossack on almost a daily basis talking about the legal issues, talking about the evidence, and talking about the concerns of the trial. I'm looking forward to hearing what Ms. Van Susteren has to say about the topic because of the experience that she has. I will also, in order to keep the program moving along, I'll introduce Roger as well. And Roger, like Greta, has been a courtroom litigator with lengthy experience. And I think on the basis of their experience in connection in particular with both of them commenting on the Simpson trial, like both of us, like all of us, they were sitting there, they were watching the television when the chase first started. And one of the things that Roger Cossack had mentioned to me is that when the original chase of the Bronco down the freeway was taking place, none of us knew that was going to happen. He was on his way to the movies. And he had an engagement to go see a movie. The telephone rang. He picked up the phone. And that was how he got involved on the legal commentary on the O.J. Simpson case. And fortunately for both of us, and for all of us, Roger picked up the phone and answered it so that we had an opportunity to hear both Greta and Roger's comments on the O.J. Simpson case. Roger, like Greta, has been a courtroom litigator for a long time. He started out, he graduated from UCLA Law School. He then went to work as a deputy district attorney at Los Angeles. So he has a prosecutor's view of cases. He then went into the law school and served as an assistant dean for UCLA Law School, so he's had an educational background as well. And he has also been involved in numerous cases involving very diverse issues, including a lot of murder cases as well. Fortunately, we are going to have the opportunity to hear both of their views on the role of the media and a fair trial, and whether, in fact, a public figure can get a fair trial today. And I will move away from the stand and give it over to our speakers. Thank you.
You want me to stand up there next to you?
No, sorry. I think I can handle this. You know, I've just spent the last year and a half teaching Roger the law, so I'm very pleased to have the opportunity to address you. I'm also grateful to Doris. She didn't mention the fact that I had done the commentary for the Lorena Bobbitt case. My mother, who lives in Appleton, Wisconsin, was horrified at my language on the Lorena Bobbitt case, and it's been very difficult to get reservations in my home for holidays ever since. It's very exciting for me. I love being back in the Midwest. It's where I'm from, and I'm glad that you all are Green Bay Packer fans instead of Chicago Bear fans. I've been assured by the dean that that is true. It's particularly pleasing to me because I understand from looking at Roger Cossack's name tag that he's now in my law firm, and on the way back I'm going to be talking about the capital contribution I'm sure Roger wants to make. But all kidding aside, I am very pleased to be here. And I just want to get a little idea from the audience. How many people here watch 75% of the trial or more? And of those who watch 75% and more of the student section, I assume that most of you hope to graduate in spite of being away from your classes. How many people here think O.J. Simpson is innocent? How many people here think that the jury was correct in its finding that the prosecution had not met its burden beyond a reasonable doubt? How many people here think O.J. Simpson is guilty? Okay, now I know what my audience is. What I've told is the purpose of the symposium is to determine whether or not a public figure can get a fair trial in this country. The answer is yes, and so now I'll turn over to Roger. I think if we were to pose that question to the real parties in interest, O.J. Simpson would be the real party in interest in this case. I think that O.J. Simpson would have to say yes. I think that he would conclude he got a fair trial. He got raked over the coals in the media, but he certainly got a fair trial. If we were to pose that question to William Kennedy Smith, I think we'd probably get the same answer, although he too suffered at the hands of the media, maybe deserved, maybe not. But why do we have cameras in the courtroom? You know, it's a funny thing. A lot of people are talking about whether it's good or it's bad. But, you know, the reason we have cameras in the courtroom is because we have a Constitution. And a Constitution speaks to the First Amendment. The media has a right to be in there. Now, it doesn't say, you know, that cameras have a right to be in the courtroom, or it doesn't say that print journalism shouldn't be there. But the Constitution has said that there is freedom of press in this country. Obviously, when our forefathers developed the Constitution, wrote the Constitution, they didn't anticipate TV cameras, but that is really where we must start. The second thing that's important to pay attention to the fact is that the Sixth Amendment talks about an open trial. And in this particular case, O.J. Simpson said he wanted cameras in the courtroom. His lawyers were asked, and they said that they did not oppose, and in fact wanted cameras in the courtroom. So did the DAs. Everybody wanted cameras in the courtroom, and for important reasons, that the American people could watch this trial, because that is part of our Constitution. And, you know, despite the criticism, the one thing that I've been screaming at Roger about for the last year and a half is that constitutional rights are not technicalities. You know, there's a lot of screaming about the Fourth Amendment when evidence is excluded. Well, the Constitution simply is not a technicality. And if anything, the cameras are in fact a restoration of very fundamental and basic principles. Probably the beginning of this huge debate about cameras in the courtroom goes back to the Lindbergh trial in the 20s, when cameras were sneaked into the courtroom. And everybody was horrified at the circus-like atmosphere as a result of the cameras in the courtroom. And people saw what went on in that courtroom. And it's as a result, the American Bar Association took a stand after that and banned courtrooms. They should ban courtrooms maybe, but they banned cameras in the courtroom. And it's always been so strange to me because, you know, it really was a deviation from the Constitution in many ways, and instead a reaction to the public clamor, questions about taste. People didn't like how it seemed. It seemed unseemly, but they never really addressed the question about whether or not it inhibited the fairness of the proceeding. And in the O.J. Simpson case, we have the same problem where people are complaining about the cameras in the courtroom, but if you actually take a look at it and dissect it, there really weren't any problems with cameras in the courtroom. In fact, it's simply a question of taste. And that's really, I think, where the media needs to examine its conduct. I would defend to the end of the earth the tabloids to write a mean, nasty story about me. Because I'm a firm believer in the First Amendment. However, there are times when the tabloids and tabloid journalism, television, and even what we consider to be legitimate television and legitimate press really need to exercise good taste. For instance, I'm not particularly interested in Marcia Clark's hairstyle. I'm not particularly interested in her child custody problems. Now, I know Roger wants to know where Johnny Cochran got that mustard yellow suit. and the tie. And I've been trying to tell him that that's not important, that that's a question of taste again, because Roger, next time he tries a case, wants to wear a mustard yellow suit. But I keep telling him we don't do that on the East Coast, Roger. But that's really where the journalists need to draw the line and need to be more responsible. And fortunately, the people in this country have an ability to put responsibility back into journalism by hitting the remote, hitting the power button, or to change channels. And of course, in print journalism, you don't have to buy the newspaper. It'd be a lot better if the American people didn't have to speak up on questions of taste. But the bottom line is that they do. And that's the real problem here. It's not a question of whether or not a public figure can get a fair trial. O.J. Simpson would say yes. William Kennedy Smith would say yes. But it's really a question of taste. Now, obviously, if this trial had been an instance where the jury had not been sequestered, there'd be a different issue. The reason O.J. Simpson was able to get a fair trial was a combination of things. One is that this is one of the rare instances in a criminal case in this country in which there was a level playing field. Of course, it was also the Employment Act for lawyers in the state of California, but it was also one of the few instances where there was a level playing field. But the other thing is that the jury was sequestered. And when you have juries are sequestered, we don't have to worry particularly about what the media is doing, because presumably they aren't hearing anything about what's going on. Now, I say presumably. There are lots of stories about jurors, not in the Simpson case, I've heard none, but about jurors having leaks to them which would perhaps poison them, leaks from information that's disseminated through the media. But as long as that jury is sequestered, we have protected the system, and we enable a public figure to get a safe trial. But it's important. Public figures want cameras in the courtroom, because that does give the most exact accounting of what went on. I think the people that did watch this trial are satisfied with the jury verdict. And before this verdict came down, one of the biggest things I worried about was that the American people, some of them, would be critical of this jury after they'd served for 9 months doing their job, that some people would be critical and say they were stupid, that they were naive, that they voted the way they did because of race or gender. But that was my biggest worry going into the verdict. And of course, we do have that. We do have a lot of people complaining and insulting these people, and these people who were not, they weren't volunteers. Most people don't volunteer for jury service. You get drafted, you get the notice, you show up, and unfortunately, you answer the questions, and the lawyers tag you, and you're it. But it's very troubling when jurors are insulted, and of course, that is what has happened, at least in this case, and has happened in most cases in this country. We have a lot of people who think they're a lot smarter than jurors, and a lot of people make those comments who, A, didn't sit through the trial, and B, probably would do everything they could to get out of jury service. But the cameras in the courtroom are important, and they're important to the people on trial. It's not like print journalism, where there is a risk that you are getting incomplete information, which assuredly you are. I mean, a print journalist doesn't have the time to transcribe everything that happened during the day, and you don't have time to read it. And it's secondhand information. It's how one person perceives what happens during a trial. And so the problem that you have with print journalism and even TV journalism on the courthouse steps is you're getting incomplete and secondhand information. Many defendants want the American people to hear everything. And gavel-to-gavel coverage is one of the ways that you enable everybody to see everything. The history of cameras in the courtroom at CNN is, fortunately, maybe not so fortunately, those who don't like my comments, I've been part of since the very beginning. CNN started with William Kennedy Smith back in December of 1990 or 1991. And oddly enough, I've still been with CNN ever since then. But It was about the same time that Court TV started to put trials on television. And my only objection at the time to William Kennedy Smith, and again, this isn't necessarily a question of right to open trials or the First Amendment issue, but I thought that there was a bias by the media because every single TV station that had any clips on the trial did one thing which I thought was grossly unfair, and that was they put that blue dot around the woman who was accusing William Kennedy Smith of rape. And the problem with that is that when the media decided to do that, and they did that because of issues of shield laws in various states, is the media was taking a position. The media, by virtue of the fact that they were willing to shield her and not shield him, was making a determination, I think, that he was guilty. And I think that's a huge mistake that the media makes. As it turned out, the jury determined that he was not guilty. And of course, she went on television live and the blue dot was gone when she was interviewed. But I think that's the danger, is if you keep seeing, if you watch the William Kennedy Smith trial, and when you watched her testify and you saw her shielded and protected, it gave you the impression that everybody thought she was responsible, that she was telling the truth. And I think that's the danger. It's not so much being open. It's not so much having the exposure. It's when the media takes sides. And I'm certainly not a fan of rape or domestic violence, but I certainly am a fan of let's do this fairly and let's do this right. And then, of course, a public figure does get a fair trial. And I think that was probably one of the big problems at the beginning with William Kennedy Smith. One, there's been a lot of backlash as a result of the O.J. Simpson case. I've just heard now that Illinois has this introduction of this possible law that you can't have jury consultants in the courtroom. That obviously was introduced by someone who didn't like the verdict or thought the verdict was wrong. I dare say I really would like to know whether the person who introduced that statute watched the entire trial, because I think that would be extremely telling. Because I think that the verdict in the William Kennedy Smith, or in the O.J. Simpson case, I didn't say O.J. Simpson was innocent, by the way, but I think the verdict was a very reasoned one, and I could sit here for 10 minutes and rattle off all the gross errors in the prosecution case, not to the fault of the prosecutors, but just in the presentation of the case. But I think that's our biggest problem, is that we have a knee-jerk reaction from people who are unhappy with the verdict. And the reason they're unhappy, I think, is they simply didn't watch the trial. In spite of all the circus-like atmosphere, that was one of the finest trials I think the American people will see. No trial is perfect. I think that the O.J. Simpson case was about 7 months too long. I don't know the judges here in Cook County. I've heard a lot about Cook County, though, over the years. I've heard a lot about the judges in Cook County, too. But I don't think that there is a judge in this county that would have tried this case, at least I don't think, that would have taken more than 2 months. This was an extraordinarily fair trial. I didn't agree with all the rulings, and I think many of the rulings are reversible error. But I think all in all, and I think that's what you got to look at, all in all, did both sides have a full opportunity to present his or her case? And the state certainly had a full opportunity to present its case, and the defense then had a full opportunity to present its case as well. The problem in the O.J. Simpson case was Judge Ito. Judge Ito, I think, is a very fine man, a very decent guy. I think he's a very bright guy. But I think that the problem wasn't the cameras, but in Judge Ito's inability to run that courtroom. And lawyers, and you law students will learn this when you get out, when you hit the pavement, lawyers, if they can, I hate to use this expression, but if they can get away with murder, they will get away with murder. And just the idea in opening statements that the lawyers took 3 days, most murder trials in Mississippi are tried in 3 days. And not that we should aspire to do it like Mississippi, but 3 days for an opening statement from one side and 3 days for the other side is absurd. Most judges would say, how much time do you need? And you say, well, I need 3 hours. You need 3 hours? Yes. Good. You got an hour. Use your best statements. That's the way most trials are done. But Judge Ito, by virtue of his desire, and perhaps he wanted to appear overly fair and just let both sides try the case as much as possible. He didn't want to seem like an overbearing judge. he let the lawyers go on and on and on. I've never seen so much repetition in my entire life. It drove me absolutely nuts listening to it. And, and that really was the problem with the case. It wasn't first of all, I'll defend the case as being fair. But, I mean, for those who complain that it wasn't fair, and I obviously have trouble with some of Judge Ito's rulings, and some which I think would have reversed the case had it gone on. But all in all, I think it was an effort to have a fair trial, and that we shouldn't have a knee-jerk reaction and all of a sudden decide we want to revamp a system that has worked for decades and decades and decades in this country based on the fact that some politicians are dissatisfied with the verdict, and I suspect that they didn't watch the case. There's some criticism that there is grandstanding to the cameras. And in looking back, I can identify 2 instances where there was grandstanding to the cameras. Now, I know the lawyers did do some grandstanding. I just can't catch them at it. But I'm sure that there was some grandstanding. I mean, a lot of them were had some pretty fancy clothes and got themselves pretty duded up for the trial, and you don't do that for your run-of-the-mill case. I mean, most defense lawyers, their clothes hardly match, and they don't comb their hair too much. But they were, so there must have been some. I can't catch them at it, or I can find few instances. But unfortunately, I did find 2 instances in which Judge Ito did, and that's a little troubling. Judge Ito, I don't know, for those of you who did watch it, in the very beginning of the trial, brought to the courtroom, and I think it's a result of Mike Royko, who's one of you guys, right? Isn't he from Chicago? He brought in, I should know that, right? He brought in boxes and boxes of letters, put them right in front of the courtroom. He says, "This is public opinion." That to me scared me, because, judges are supposed to be immune to public opinion. And that was the first indication to me, and I think that was in last September, that there might be a problem, that Judge Ito might be too sensitive, in spite of being a good, decent man. The fact that he would have his attention on what public opinion was, I thought was scary as a lawyer, and being a real purist in terms of the Constitution and fundamental rights. The mob's supposed to be clamoring outside, and the judge is supposed to act as though he's never even heard of, the noise or the screaming or the people calling for lynching or whatever it is. The judge is supposed to be above that. That was troubling, and that was the first indication to me that Judge Ito needed to have some re-education in terms of, the role of a judge in running a trial. The second thing that bothered me was the Furman tapes. Not so much his ruling, which I disagreed with in some aspects of it, but you never agree with what judges do all the time. You don't agree with the other side. You're not supposed to. I mean, that's the whole point of the adversarial system, that you have different points of view. Judge gets to call the shots, though, and if you don't like them, you take them down the highway to the Court of Appeals. But what Judge Ito did that bothered me was he said that the American people ought to hear all these tapes. Now, that was a clue. He's only going to let in a portion of it. But the fact that he was concerned that the American people hear that, it's not his business. He needs to run that courtroom. And that's, again, what is so troubling, is that the judge is supposed to be immune to that. But when you've got a judge who's got his eyes someplace else and his attention someplace else, rather than the courtroom, you got problems. You want a judge who's going to follow just the law. He's going to be fair to both sides, completely, to the prosecution and to the defense, and in doing so be completely, have the thickest skin you ever saw in your life, and not be troubled by what the people are saying. The problem that Judge Ito created is that his grandstanding was the problem. He's lucky. He hit it lucky. We had 12 jurors at the end, and we also had a verdict at the end. And I think that all in all, that is a good product. But I think he got extraordinarily lucky. The analysis in terms of whether a public figure can get a fair trial almost turns not so much on the media, but on the willingness of us as American people to serve on juries and to do so in a fair way. And I'll tell you that being in the courtroom is a completely different world than being out here. Out here we take pot shots at people and you say, oh, he's guilty as can be, or he's innocent, he's getting railroaded, or whatever. But when you cross that threshold and you become a juror, things change. And I have an enormous amount of respect for the American people and for our jury system. And I think that when those jurors do take that oath, when you realize sitting there that your decision is going to determine something very important to two sides, I think you take that seriously. And I think that there are a few crackpot juries that have made some wild decisions that have maybe been poisoned or whatever. But unfortunately, those are the ones that usually capture the media attention. And what doesn't capture the media attention is the thousands and thousands of jury trials in this country every year that are good jury trials with American citizens doing the best that they can. You know, I was going to go through a little bit and talk about the trial, but having seen how the hands went up in terms of, you know, whether or not they thought the prosecution did successfully meet its burden of proof, you know, it became quite evident to me that, you know, that I don't have to go through any of the areas where a reasonable person could find reasonable doubt, but still think he's guilty. I mean, it's perfectly intellectually honest to think he's guilty, but to think that the prosecution didn't prove its case beyond a reasonable doubt. So I'm not going to go through that aspect of it, other than this. A lot of people are critical of the prosecution team because they lost. Frankly, I don't think the prosecution lost. And it's not for those reasons where, you know, where it says, I think it's something etched on Justice Department or something, the prosecution never loses when justice is attained or something like that. I don't know what it is. That's not why. It's because I think we've got to look really what happened with these prosecutors. They were assigned to the case sometime in the late afternoon of June 13th, 1994. The homicide occurred on the night of June 12th. Although God knows we don't know the time. We don't have those wailing dogs here to tell us the exact time. In fact, I assume that my time to speak will end as soon as I hear the wailing dogs, right? By the time they were assigned that case, they'd lost. And they hadn't lost because they're lousy lawyers or they're bad prosecutors. But they had lost because they had Mark Fuhrman on the case. And they had lost because they had Philip Van Etter on the case. And because Mr. Fung and Miss Mazzola had been to the scene. Mark Fuhrman needs very little discussion other than this. It is perhaps one of the greatest tragedies to ask our prosecutors in this country to try cases when they have people like Mark Fuhrman as witnesses. And Mark Fuhrman is no surprise. They knew about him, not they, but the LAPD knew about him for years. And you know, when the rest of us have to walk the streets of this country, we hope that our police are there to do a good job. And I'll tell you one thing, not to weed out that bad apple many, many years before, I think is one of the great tragedies that has been exposed in this country, and hopefully a lesson will be learned. So frankly, I don't believe that other police officers didn't know about him. Now, whether or not he planted the glove, I don't know, and you know, it really isn't the issue for me. The question is whether we have people out there who are so housed in hostility and anger that they are incapable of doing their job. And I think Mark Fuhrman was incapable of doing their job. I don't think there's anything that Marcia Clark or Christopher Darden could have done to recover from the Mark Fuhrman issue. Some people have suggested, well, they shouldn't have called him as a witness, and they shouldn't have introduced the glove. Well, that seems like sort of an interesting idea. However, do you know who the first person I would call to the stand if I were the defense lawyer if the prosecution hadn't called him? Or do you know who I would be jumping up and down in closing argument asking the jurors about? Mark Fuhrman. I'd say, why didn't the prosecution call this person? I would have built my whole case around his absence, or I would have called him. Probably would have built it around his absence, since I'd worry that it might backfire me if I actually put him on the stand. But they were cooked. This was not someone that the prosecution chose. This was someone who was on the case, an essential part of the case before they even hit the pavement. So there really wasn't much they could do. And you know, it really is awkward when you put a prosecution team into the posture of doing damage control from day one. You know, prosecutors are supposed to go forward, have powerful evidence, proof beyond a reasonable doubt, but it really weakened them when they've constantly got to try to figure out how to do damage control. Philip Van Etter seemed like a nice, decent guy, even though Judge Ito later found him to have a reckless disregard for the truth in an affidavit that he did secure later in connection with the case. You know, people can make mistakes. Maybe it was just an accident that he put things in the affidavit that were wrong. And I say that, with all, I grew up in a community, by the way, where I never believed police could plant evidence. In my community in Appleton, Wisconsin, police gave the safety talks at the Catholic grade school, came in, showed you, how to cross the street, and they pulled cats out of trees. They didn't do things like this, so it's sort of a rude awakening. And that's one thing you got to think of in terms of even jury selection or in juries that, what are people sort of experience? Not that they're racist or anything, oftentimes it's economic lines, but if you grew up in a neighborhood where you have experienced situations where police can do bad things, you come into the courtroom not as a racist, but knowing that it is possible. And, there were some people came to this case having been in environments where police did bad things. So, I say about Van Adder, he seemed like a hell of a nice guy, but he did something that was very damaging to the prosecution case. And again, this is before the prosecutors got on the case. Not that I'm a big apologist for the prosecutors, but I think this is a realistic assessment. And that's that he had O.J. Simpson's blood, and he was walking around with it for several hours in a test tube. What he did is he was given the defense information which showed an opportunity to plant evidence, because not only did he have this test tube of O.J. Simpson's blood, and not only was he walking around the premises with an opportunity to plant it, but we know 1.5 milliliters of blood may have been missing from that test tube. And from estimates, 1.5 milliliters could equal 130 droplets of blood, is what one expert told me. So Van Adder gave the defense this ammunition because he was sloppy walking around the scene. Sloppy, I don't mean sloppy in terms of distributing the blood, but sloppy in terms of walking around with the blood. The other problem, too, is that blood mysteriously showed up on the murder scene about 3 weeks after the murder. Could have been there the night of the murder, but nobody spotted it. But it showed up on the gate at the Bundy residence. And it may have had, and there was a dispute on both sides, but it may have had EDTA in it, which is a preservative, which would have been in that test tube when they drew O.J. Simpson's blood. So again, this was a problem that the prosecution had by the time they were even assigned to the case. The Fung and Mazzola problems, the Fung and Mazzola collected the blood. They were the technicians, criminalists. And Fung turned out to be a major disaster. And it's not so much for the way they collected the blood, because the contamination theory I don't think was particularly damning. I think that the more damaging thing for the jury was the fact that it could have been planted. But Fung testified before the grand jury that it was he who had collected the blood. Well, it was not. It was Mazzola, but he was taking credit. And unfortunately, when he testified on the witness stand about 8 months later, it was pointed out that he had lied before the grand jury. He hadn't collected. So these were problems that the prosecution team had before they even got on the case. So, the problem with the case, I really don't think, was so much a prosecution problem, but really sort of the LAPD. And I really think it behooves us to make sure that our police force is, competent, able, has sufficient resources to do their work right, and hopefully they're going to be responsible enough to weed out the other people so that we don't have, scenes like we had in the Simpson case. The other thing that I want to talk about is something that I give Roger a hard time about, and this has to do almost directly with, can a public figure get a fair trial? I don't get it. But, maybe Roger will get up here and tell you why. But why is it that trials in California take so long? There was the Manhattan Beach case. It took was it 3 years, Roger? 9 years. 9 years. 2 years. Well, I added a year. 2 years for a child molesting case, which was another disaster. We have the orphan trial, Menendez brothers.
The Menendez brothers.
The first round took over 6 months. I tried a case up in Northern California, which is a week trial in any other jurisdiction. I was there 9 months in about 120-degree weather, which was just awful with lousy hotels.
This is like all my fault.
It's so bizarre. It's like the legal culture. And I know you guys had one in Illinois a few years ago, some damage trial civil trial that took forever. And so maybe I don't have a friendly environment in terms of this argument. But when you talk about fairness, you got to talk about swift justice for both sides. And I think can the state get a fair trial in a long trial? I don't know. And I could, obviously O.J. Simpson thinks he got a fair trial, but I really think we have to sort of, examine the legal culture in California. And another perfect example, the Polly Klaas case, who was killed, she was a young girl killed in Northern California by Richard Allen Davis. It's a death penalty case where he confessed. It started the same day as the Susan Smith case, which is also a death penalty case with a confession. Same day in South Carolina. I don't think they're out of jury selection in Northern California. There was aborted for a little while because they had some jury problems. But, again, it's almost the legal culture. And I think we're misguided to think it's the cameras or the media. I think if we're really talking about fairness, we're talking a little bit in terms of swift justice. And, I'm a big California finger pointer because just historically and statistically, I think that California tries things a lot slower. And the Susan Smith case was rather swift, and I think most people are pretty much satisfied with the results. The problem with a case like Simpson is that it oftentimes becomes the scapegoat of politicians, and I think it really behooves us as lawyers and law students, soon to be lawyers, is to look back and see what has worked. And all in all, our system of justice has worked. Unanimous verdicts is now under assault. In the state of California, Governor Wilson is now calling for non-unanimous verdicts in criminal cases. They have it in civil cases. And the problem is that, for the most part, cases do resolve fairly. They do resolve to a verdict. It's a very small percentage of hung juries. It was something I think California did a study. It was about, 8%? 90%
of all juries reach a verdict.
Yeah, so at least 10% are hung juries. And the problem is that the one thing that bothers me is that when lawyers are so worried about their image and so worried about what's good taste, that they lose sight of the really fundamental principles of the Constitution and what has worked. And when we sort of fall prey to the politician's desire to fix something that ain't broke. I'm always in the market for improving things, but I'm really opposed to taking draconian steps that are an assault on the system, which I dare say I'll peg our system against any system in the world in terms of what's fair. I regret that the media is sometimes tasteless. I regret sometimes things that I've said, and certainly some things that later I've discovered I've been dead wrong about. And believe me, my commentary has not been without criticism and justified criticism. But what I hope more is that we are not bamboozled by the press. I hope we're not like Judge Ito, and we worry about what the people in the country, sort of the hysteria of politicians, and that we change the system. I think we really need to be proud of the American people, proud of our system. Let's always work to make it better and fairer. But I do hope that we be smart about this and approach it from a logical fashion. And I regret that public figures endure so much punishment. And there's nothing worse than taking a public figure on a ride and finding out the public figure is innocent. I didn't say. And I'm not. Again, the ones that walk the streets because the jury has found them not guilty doesn't mean they're innocent. But there are some people who are tried that are flat out innocent, and it is brutal what happens to them. But I hope that we have the good sense to treat them fairly afterwards and acknowledge the fact that we've made a mistake. So with that, I say, I want to turn it over to Roger, who will tell you whether or not O.J. Simpson is innocent or not. Roger does know. We always get asked that question. The first thing I always hear is people always say to me, "Oh, you're so short." It's the first thing I hear. And then the second thing they say to me is he innocent? And of course, I have no clue whether he's innocent or not. But I always very courageously say, Roger knows.
Well, you see, I get to sit next to her every day and endure this. And it's not easy sitting next to this bright woman who has most of the answers and all of the comebacks, and a lot sharper than you would hope, Sometimes we do these speeches, and we do them for women's groups. And guys, I can't tell you how horrible that is. And they just fawn all over. "Oh, Greta, you're so wonderful, you're so bright, you're so charming."
Yeah, but the only chance he has to get a date.
That's exactly right. But unfortunately, she sets him off, and and I never. Anyway, I want to just tell you that I want to thank you for your introduction. And thank you for leaving out something in my introduction. I have been to the United States Supreme Court, and in my career as an attorney. And I went there on a case that perhaps some of you law students have studied called United States versus Leon. I am the guy that's responsible for ending the Fourth Amendment as we used to know it in this country. There used to be an exclusionary rule in this country for searches that were declared illegal. And I got to the United States Supreme Court on that case. And when I was through, it is probably the main reason why you don't read too many Fourth Amendment cases anymore, because there really isn't too much Fourth Amendment law to discuss anymore, because the case that I ended up before the United States Supreme Court and lost is the one that ended the Fourth Amendment as we know it. And after that decision came down, some friends of mine called me up, and I was, of course, heartbroken to be on the wrong end of a case that I really didn't want to be there on anyway. I had won the motion at the district court and won the motion before the Ninth Circuit Court of Appeals, and the government petitioned for certiorari. And when the United States Supreme Court took it, I knew they didn't take it to congratulate me on what a wonderful job I had done. And but I prepared very hard anyway, and I argued my heart out. And like most things, you're able to convince yourself that even though you're going an absolute loser, you're going to be a winner because you were so articulate and so well prepared. And of course, the decision came down 6-3 with 3 brilliant justices voting for me and 6 political hacks voting on the other side. But anyway, some friends of mine called me up and they said, listen, don't feel bad. You did the best you could. You fought the battle. You know, you prepared. You were great. You wrote a great brief. But do us a favor and try and stay away from the rest of the Bill of Rights. So, I knew, you know, that perhaps the law, I should be thinking about another business. And so when OJ, and that's right. So when OJ came along, you know, less destructive, you know. Historically in this country, there's been over 300 trials that have been televised. Court TV has done quite well for a number of years televising trials that some of us from time to time when we're flipping with our changer suddenly come across Court TV and there's an interesting trial going on and we watch for a little while and the outcome comes along and sometimes we read about it in the paper or sometimes we don't or sometimes we get hooked for a few days, but nothing seems to happen too much. And you know, in this country, historically the lawyer and the trial and the courthouse has played a very interesting role, a very important role. You know, years ago, before there was television, yes, there was a life before television. Greta and I went to the Rock and Roll Hall of Fame, and they opened it up by saying, they show you a movie, and it says, can you imagine a time before there was rock and roll? You know, I said, my gosh, you know, can you imagine a time before there? Anyway, there was a time before television, and there was even a time, and that was radio, and there was a time even before radio, and people had to do a horrible thing before there were those two events. They had to talk to each other and they had to look for entertainment in conversation. And that's when we read about and we see these pictures in our history book of the great orators, people who would come to the Chautauquas in these villages and speak, and the community would come around and listen to the great orators and people who really could weave spells with their use of the English language. And many of those people were lawyers. And that's why when you see the courthouse in many of the small towns in America, you see that the courthouse is built in the town square and has a very prominent role in the geography of the town. And they're beautifully built, and they're usually one courtroom, which is big and ornate and lovely wooden benches, because that is where many times people would go to be entertained, because the courtroom and the lawyers were the entertainment. This is even before radio and television. So the history of lawyers as entertainers is not a necessarily new idea, particularly in the United States of America. Lincoln was a lawyer, the Lincoln-Douglas debates, people would come to hear the lawyers speak. So the notion that that has evolved into the idea that we have a camera in the courtroom to see lawyers who admittedly aren't half as good as the lawyers that we could see at the turn of the century is in and of itself not such an unusual idea. And what it tells us, the camera in the courtroom, as Greta points out, is it shows us on court TV what goes on in trials. And, you know, most of the time, it's not that interesting. But every now and then, a set of facts occur which strike a responsive chord in the American public. And so it was with O.J. Simpson. Now, the question that's posed today is, can a celebrity get a fair trial? Well, before I answer that question, and I will answer that question, let me bring up this issue. Just for some things to think about. The real question is, can the state does the state have a chance to have an equally fair trial when they are trying someone who is a beloved public figure? Now, for example, recently we just had the Selena case. And in the Selena case, which is the opposite of the O.J. Simpson case, we had the victim, who was a beloved, adored figure in the southwestern part of the United States of America, so much so that people were driving around with signs in the back of their pickup truck saying, "Burn Yolanda," before the decision was even made. There were people with signs outside the courtroom every day saying, "Execute Yolanda. Yolanda is guilty. O.J. got away with it. Yolanda won't get away with it." And the reason is because we had, in this case, a beloved figure who was the subject of a murder, and the victim, and the defendant was, a nobody, wasn't a beloved figure. So in that case, the real question was, could this woman in Houston, Texas, ever get a fair trial? The question in the O.J. Simpson case, I think, was, could the state ever get a fair trial? And I don't have an answer for that, but just to show you the reverse of these situations, when this subject was brought up here today, I think it was because everybody thought, or when they put this symposium together, I think the implication was that O.J. Simpson was going to be convicted. The issue of can a celebrity get a fair trial really is much more important if Simpson's convicted than it is if he's not convicted. So we should think about it in terms of both sides being able to get a fair trial. Now, unlike Greta, I believe that the prosecution should be held to task for what happened in the O.J. Simpson trial. And I believe that in many ways they brought it on themselves. And I saw the way you all voted at the beginning. So let me just point some things out to you. First of all, we all are equal under the law. Everybody agrees with that, right? Everybody were equal under the law? Okay, but you all agree with me that some are more equal under the law than others. Okay? And let me just suggest to you that if you're going to take O.J. Simpson and you're going to try him for a brutal double murder in Los Angeles County, where he won the Heisman Trophy, running the ball for USC and is as close to a hero as anyone can ever be, and you are going to try and convict him on circumstantial evidence only, which means that you don't have an eyewitness to the murder, you don't have a murder weapon, and you don't have a confession. And you're going to throw into the mix a racist cop who brags about how he likes to plant evidence on African Americans. And how you are also going to take this attitude that it's okay because I have the best evidence in the world. I have DNA evidence, which is so compelling that all you have to do is hear it and the case is over. There's only one problem. You better make it so that I can understand it. And as I have told and said before, Greta and I watched this DNA and tried very hard. We had books, we had people who would come in and try and explain it to us, and we had the benefit of an education. And I must tell you, after about 2 weeks, I was hopelessly lost. And I was, as I always say, I was down to my last nanogram. I was nanogrammed out, and they just lost me. And I have the benefit of an education, and I had the benefit of some good books on, your friend DNA. And I got to tell you that I was lost. And it doesn't surprise me that jurors didn't pay much attention to evidence that they too couldn't understand, because I don't think that it was presented in an understandable way. We had Lisa Kahn, who's the DNA expert for the Los Angeles County District Attorney's Office, on our show, which was shown today, as a matter of fact, the show that we taped. And we asked her, we said, how good can your evidence be if nobody understands it? I mean, what good is it? You just can't say DNA and then sort of step back with a smile on your face and go, there it is, DNA. We said it, and Dr. Cotton was here. Because, in fact, I believe that the prosecution made some serious mistakes that they themselves have to take the responsibility for. For example, everyone agrees with me, I'm sure, that Mark Fuhrman is a racist. Now, having said that, I think we can all agree that the Los Angeles County District Attorney's Office either knew or should have known that Mark Fuhrman was a racist when they chose to put him up on the witness stand. In fact, one can even conclude that they must have known, because they had all of these files that he had where he had tried to get off the force by claiming that he was a racist and no longer could make rational decisions regarding blacks and Latin American and Latinos because of the work that he had done on the police force. For some reason, for the Los Angeles Police Department, that wasn't good enough. They said, "What? Just what? You want to like plant evidence on blacks? Fine, sit down. You're with us." And they kept him on. The district attorney's office clearly knew about Mark Fuhrman, and yet what did they do? They tried to sell Mark Fuhrman to the jury and hide that fact. They tried to hide that fact. I can still remember Marcia Clark walking him to the witness stand and complaining publicly about the horrors that this man had to go through as he got up there and lied through his teeth. That was a disingenuous activity by Marcia Clark and by the district attorney's office that blew up in their face when the tapes came out. Instead of coming forward and putting an honest or a straightforward spin on what Mark Fuhrman was, they tried to hide it from the jury. Well, you know, there's just so many times you can begin to hide things from jury or you mislead juries that juries are going to begin to lose respect for what you're trying to say. Let me give you another example. How many people really believe that it took 4 police officers or that 4 police officers were going from the murder scene at Bundy at 5 o'clock in the morning to O.J. Simpson's house on Rockingham because they wanted to console O.J.? You know, that's the spin that they put on that. Now, that's just non-believable, and yet that's what they told the jury, and that was the position that the district attorney's office took. That, too, blew up in their face because it became clear that that just wasn't the truth. Let me give you another example. According to the district attorney's office, their theory on how this murder was committed went like this. O.J. Simpson and Cato Coale went for a hamburger. Simpson then dropped off Coale, drove to the murder scene, confronted 2 people, did a vicious butchered murder, killed them both, stabbed them a number of times. No one ever heard any of this. He then jumped in his car, drove back to Rockingham, came in the back way, bumped into his air conditioner, threw his glove, got rid of all the rest of his clothes except this pair of socks, which he somehow left on the bed for everybody to see, took a shower, was able to get rid of all the blood that must have been on him, but was unfortunately never found within the pipes of that shower, jumped in his clothes. By the way, this last bit of activity took 5 minutes. Getting home, getting in the shower, getting whatever the clothes were, run back downstairs, jumped in the limousine, and was taken to the airport, where he got on an airplane and was noticed by 6 people who all said, "Gee, looked okay to me." Now, you know, that's inherently wrong. That crime, however the crime was committed, wasn't committed like that. That's a story that is unbelievable, but yet that is what the Los Angeles County District Attorney's Office tried to sell to that jury. They said, folks, this is how this crime happened. Now, I think that if that crime happened, I think there was more than one person involved in that crime. But the District Attorney's Office got married to this theory from day one, and they wouldn't back off on it. And I think that there was an arrogance to this prosecution that came through from the beginning to the end. Now, Greta's right when she says that they got stuck with some bad cards right from the beginning. They got stuck with Fung, and they got stuck with Mazzola, and they got stuck with bad activity, and they got stuck with a racist cop, and all of those kinds of things. But I think they played their hand totally incorrectly. I think they tried to mislead the jury. And so you wonder why this jury didn't buy a lot of this stuff. And if you think about it, and you take away the issue of, in my heart, I know he's guilty. I know this guy did it. I know he did it. And you put that aside for a moment and you say, I'm sitting on that jury. I'm going to try and get rid of all of these prejudices and all of these feelings that I have in my heart. And I'm just going to concentrate on what the evidence was that was put in front of me. And I'm going to say, do I have a reasonable doubt? And I'm going to test the prosecution's theories. I'm going to go on what they told me, how this crime was committed, what those police officers did, this Fuhrman, who they tried to mislead me on, and I'm going to go and I'm going to test that, and I'm going to see whether or not I have a reasonable doubt. And I can say to you that if you do it exactly as that, it is not so unusual that a jury would have a reasonable doubt. Now, what seems to be the problem? The problem is that, and to get back to our original topic about the media or the camera in the courtroom, is that what this camera did for us was it showed us a whole lot of things about ourselves that we're not particularly comfortable with. And so, like most issues that we're not uncomfortable with, we have a tendency to strike out and be angry at the messenger. And the messenger in this case is the media and the television. I've always felt, and Greta agrees with me on this, is that if you wanted to say, Greta and Roger, you know, you were prejudiced, or if you want to make a legitimate criticism of something I've said on television or something Greta said about what the camera saw that day, that's a legitimate issue. I think you can say, you know, you made it sound this, and in fact that wasn't the correct way. That's okay. But what I think that you can't say is that the message that was brought to you by the camera, you can't criticize that message, because what that message told us was a whole lot of things. First of all, it uncovered many layers of racism that exist in this country, and it showed that there is perhaps something that none of us wish to confront, but it's apparent that we're going to have to, is the division among the races in this country. I read those polls every day. I talk to people every day like Greta does. It is clear to me that, and it's clear to all of us, that the viewpoint as to whether or not O.J. Simpson was guilty or innocent or proven or not proven is incredibly different depending on the color of your skin. If you're an African American, chances are you believe that the verdict was just and you believe that he was innocent, and you're much more ready to believe that those cops planted the evidence on him. If you're not, chances are you believe that this was a crazy verdict and that it was done, and that African Americans protected O.J. Simpson, and in fact there was more than enough evidence to convict him. That is at least what the polls show in this country. And I happen to think that that's really a shame, and that's why I spend so much time with you talking about what I consider to be the real holes in the prosecution's case, and why a jury could reasonably decide that there was reasonable doubt in this case. I have said this, and I'll say it again, I do not believe that there is a jurisdiction in this country where, of good people, of well-meaning people, that you would have got any better than a hung jury in this case. People say, well, Garcetti should have tried this case in Santa Monica rather than in downtown Los Angeles, because he would have had a jury that consisted of, instead of 8 blacks, you would have had a jury that consisted of 8 whites. I tell you, I have practiced law in both of those jurisdictions. We'll never know, but I will tell you that in my opinion, the best you would have had out there would have been a hung jury. There is too many holes in the prosecution's case. And like Greta, you know, I don't know whether he did it or didn't do it. I have my own suspicions, but if you're asking me to sit on that jury, I am telling you there's a very rational reason why this jury could have had a reasonable doubt in this case. Now, the other issues is it shows us also the differences in how African Americans view inner city police departments as opposed to non-African Americans or non-minorities. It's clear that the experiences now, we now know that African Americans and Latinos have a much various and much different experiences with police departments than my Greta did in Appleton, Wisconsin, where they went up and took the cat out of the tree. It doesn't happen in the inner cities. And we've seen it time and time again. The Los Angeles Police Department, unfortunately for my old hometown, has a long history of racism. This just didn't happen overnight. Let me also tell you that as a former practicing defense attorney in Los Angeles, we all knew who Mark Fuhrman was. As a defense lawyer, I knew about Mark Fuhrman. Mark Fuhrman was somebody that we'd all had a run-in with at one time or another. And as a matter of fact, to give you a little inside scoop, one of the stories of this case is that Ito's wife was the highest, and is the highest ranking woman police officer on the Los Angeles Police Department. She was the commander of the West Los Angeles Police Department, where Mark Fuhrman was a detective. They had had a huge fight. Why? Because this wonderful Mark Fuhrman was a charter member and a beginner of an organization called Men Against Women. Now, you would think that perhaps, you know, what's your first clue on this one? And you would think that perhaps, here is Ito's wife, who had this tremendous argument, filed a complaint against this man. You would think the defense or the prosecution wouldn't have been so happy to have Judge Ito be the judge in this case. But nevertheless, this is a police officer that should not have been there. It is unforgivable that Mark Fuhrman was still on the police department. It is unforgivable after the kinds of admissions that he had made and the things that he had done that he was still representing us on the Los Angeles Police Department. And to talk further a little, just one other thing about the jury. Greta and I part company a little bit on this one too. Greta takes the position that It's an incorrect position, by the way, but Greta takes the position that, that juries are not to be criticized. She sees them as sort of inviolate, and that these are good people who donate their time and do their job, and when the results are in, we must leave them alone. And she feels very protective about the fact that the juror in the Simpson case are receiving a great deal of criticism. I think the juries, like anybody else, and their activities and their actions are open for criticism, not necessarily criticism in the negative sense, but criticism in the educational sense to review, and perhaps even in the negative sense. If we're claiming, in fact, that, which seems to be a favorite cry of those who believe Simpson was guilty, that this was a case of jury nullification, well, historically, if you want to talk about jury nullification in America, if anybody learned it, they learned it from white America, because some of you in the back may not be old enough to remember, but I remember smiling sheriffs in the 1950s before the civil rights movements with big grins on their face as the juries would have their arms around them as they walked them out after 20 minutes where the evidence was absolutely certain as to their compliance in the crime that they were charged with. Now, is that an excuse for jury nullification? No, it's not. But I think that we should be able to discuss whether jury nullification happened in this case. I think we should be able to discuss, if it did happen, why it happened, and to learn from it. To me, I don't think there was jury nullification in this case, because to me, I think there were too many reasons why reasonable people could have had a reasonable doubt. You want to talk about jury nullification, to me, talk about Rodney King, in which I don't even think they put up a defense, and the first Rodney King trial, and the jury acquitted him. So, you know, there's much to be learned. I believe jurors are open to criticism, like every other entity in this country, and I don't believe that they are so sacrosanct that that we have to stay away from them. Now, as far as who serves on jury, I have the Roger Cossack jury plan, which also gets my worthy colleague a little annoyed. But let me tell you how this one goes. It goes like this. I believe that one of the problems with our justice system in America is that it is sort of a national sport to figure out how to get off of jury duty. Great cocktail parties are held with great cocktail conversation about how I beat the jury. You know, what do? Here's how you do it. When you get the first questionnaire, you never fill it out, you throw it away, and then they don't have your name in there. That is the demise of the jury system, because what that means is we are not getting a jury of our peers. We are not getting a cross-section of humanity. So under the Roger Cossack plan, it goes like this. As I was explaining to you last night, there used to be a draft in this country, and in those days, everybody had to register for the draft. And while we didn't like it, from time to time, you got drafted. And the theory behind the draft was that, you know, you lived in this country, you got to pay your dues, and the way you pay your dues was that you went into the armed forces for a period of time. And while you were in the service, certain things happened to you. One of the things that happened to you was you lost your rights under the Constitution. Democracy is not a hallmark of the military service. The sergeant says, get up, and we say, okay, let's take a vote. How many want to get up this morning? We're not getting up. You know that? So that was it. And when you got out, you got your constitutional rights back. And Congress passed a law called the Soldiers and Sailors Relief Act. And what that meant was that while you were in the service, your bills were kind of stayed, so that, you know, you're giving service to the country, you're not going to get thrown out of your house. Okay. I believe that everybody should have to register for the jury. No ifs and ands about it. You reach a certain age, you register for the jury. And there's no getting out of it. Everybody has to go. And some go for a month, and some would go for 3 months, and a very few would go for 6 months. And this would mean also that there'd be more money to pay these jurors. This $5 a day business wouldn't happen. And perhaps even companies and corporations would have to throw in some money to build a pool to pay the jurors. But everybody goes. There's no getting out of it. There's no good excuses. There's no good reasons. There's no way out. You have to go. And that's part of your duty as an American citizen. And you know what else you lose? You lose the ability to write books. One of the things that I'm concerned about is this notion of being on the right jury and hitting the lottery. I am worried about jury verdicts, and I'm worried about justice, where a juror might suddenly, through the luck of the draw, suddenly end up as a juror on a famous celebrity trial and think to themselves, if I'm the right one, and if I get lucky in this case, I could either hang this jury, or I could play a role in what happens here, and I go from not having very much money to having a whole lot of money. Well, that kind of temptation has to be removed from our jurors, because that's just not the way the justice system can work. That kind of outside attraction can no longer be part of it. And as we see what's happening in the Simpson trial, I think that's a real shame. Now, Greta is a purist on this First Amendment, and I have to tell you, the fact that she let me go through all of this without jumping up and smacking me only goes to show she's on her best behavior today. And she will go along with just about everything except when I start talking about prescribing rights under the First Amendment. And I know about the First Amendment, and even out as far as California and UCLA, we just recently heard about it, but we've heard about the First Amendment. And I know how tough it is, and I know how you feel.
How tough it is to sit here and not say anything.
I know, and I know how much we hate to start talking about things that would just proscribe our wonderful rights under the First Amendment. But I believe that you cannot have situations where jurors are going to have the opportunity to hit it lucky if they end up on the right jury. So under the Cossack theory of jury service, we all have to go. I, of course, would be the commissioner. See, I don't have to go. I would be the commissioner to make sure you all go. But under the Cossack theory, we all go, and we have to serve for a certain period of time, and we would talk about jury duty the same way we used to talk about the military draft, that I got drafted, my life is interrupted for a short period of time, and then I move on. Believe me, it's not fun, it's not pleasant, but if you really want to have a representative judicial jury system in this country, you're going to have to figure out a way to have more people involve themselves. Thank you.
Well, thank you, Greta and Roger, for those very illuminating presentations. And now we're going to have a question and answer period. And we'll start off with a question each from Jack Doppelt, Associate Dean of the Medill School of Journalism, and Bernie Judge, who is the Vice President and Editor of the Chicago Law Bulletin. I've done something that's perhaps cruel and unusual for journalists. I've asked them to confine themselves to one piercing question or comment each. And then we're going to open up the floor to the rest of you here. If you do have a question, please use the mics so that we can all hear the question. Jack, you've been elected to start off.
Thanks, Mike. It's going to sound a little bit like a little bit of an odd question from a journalist sort. I find it a little disconcerting for journalist sorts, and I'm admittedly one, but you two are now too.
You bet.
For better or worse. To invoke the Constitution, to talk about the First Amendment, it's equally disconcerting to hear people tell journalists how they do that. But, you know, there's a line from The Absence of Malice, and with apologies to Winford Brimley, who does a great job in that movie. At one point he says in his wonderful Southern accent, you know and I know the Constitution don't say that. And the Constitution doesn't say that cameras in the court are required, and you know that. And any judge within a judge's discretion can take the cameras out. Any legislature in the union can take the cameras out for the entire state. And our beloved Supreme Court can reinterpret the Constitution and take the cameras out forever by finding that, lo and behold, as they did 30 years ago, that by their very nature, they deprive everybody of a fair trial. So to me, I'd reframe the question, have you guys tinker with this a little bit. It's not really a question of can the public figure get a fair trial. We found out in OJ that's not the question at all. It's really more the question, is it okay for people to get different trials in a media age? I mean, one thing we all do in the media too is we like to look at ourselves as the individual media. I'm a good reporter, you're a good reporter, Bernie's a good reporter, everybody out here, my journalism students are going to be great reporters. All true, but the media is a transforming agent. It is huge. It is enveloping. The media age goes far beyond cameras in the courts. It goes far beyond news coverage. It goes far beyond influencing just the defendant's right to a fair trial. It influences everyone, not just the jurors writing books. It influences the prosecutors writing books. It influences everyone. It's huge. With that in mind, now to me, the tougher question is, now what do you do with the omnipresent media enveloping not just within the courtroom, but outside, so that the entire individual case and the justice system and the whole high-profile cases get transformed.
First of all, let me say that I'm a purist, as Roger has noticed, when it comes to the Constitution, and that includes the First Amendment. However, to the extent that the First Amendment, as you note, is not absolute, doesn't say cameras belong in the court. In fact, there's no right to yell fire in a crowded theater. Pardon?
Falsely.
Falsely, right? That's right. Falsely. I have been thankfully corrected. And if I can understand your question, Riza, while the Constitution doesn't say cameras in the courtroom, the Constitution doesn't say a lot of things, and unfortunately that's the job of the judiciary and the rest of us to try to interpret what is meant in a new era, in an era of technology that couldn't possibly have been anticipated. And God knows what our people 100 years from now, if we still have this planet, are going to have facing them on issues like this. But the cameras should be in the courtroom because they accurately reflect everything as it happens. If there is any sort of criticism, the criticism really needs to be made of Roger and me and people like us who are commenting, because the camera doesn't lie. People like us put a spin on it. Even if we do it sort of good-naturedly or think we're doing it the right way, the fact is, everyone walks into this room with some sort of set of biases. Some of you may still like bell-bottoms. Everyone does walk in with a whole different idea. And I think the line to be drawn, and it's a very difficult one, is simply the issue of taste and responsibility. And that's a far more difficult issue. And when I spoke initially, I will defend, the Constitution. First, if I represented a media outlet who wanted to print a really mean, nasty story that was true, I would fight like a dog as a lawyer to get that, to invoke that First Amendment right. And then having won the case, I would then turn to my client and ask my client to hopefully use some good taste and responsibility, not print it since it has no social or redeeming value. I don't know where the line is drawn. I'm not really sure exactly if I have answered your question. The one thing that does bother me is that the reason courts do pull the plug on trials is this idea of decorum. And that is, again, a little bit, I don't like judges to be the ones who determine in this country, what is proper decorum. Obviously, if they're going to start throwing things, that's, out of line. But in terms of, I really have a problem when lawyers are so worried about image and decorum and lose sight of fundamental fairness. And the bottom line in a trial is, if it can be fair to both sides, not just one, but to both sides, and I think that's the first thing we have to look at, then the cameras should be in under the First Amendment. Then the next question is, do you want to limit people like Roger and me from making comments? Probably not, because of the First Amendment, but that's when you pull out the remote and you hit, the channel. But I think the bottom line is, is responsibility and good taste. I don't think you can legislate that, but I think there's peer pressure in the community, hopefully.
Let me just quickly, if I can. This was what you just heard was is one of the reasons I am absolutely crazy about Greta Van Susteren, because she's a pure romanticist. That people should do the right thing. People should be right to each other. They should reason with each other, and they should realize that they're doing the wrong thing and then stop doing it. I'm a little more cynical than that, and I think that my view of life was borne out by the O.J. Simpson trial. Now, let me tell you, if I ruled the world, what I would do. What I would do.
Would this be after you give up your job as jury commissioner?
If I ruled the world, the first thing that would happen was I certainly think that the camera, so self-serving as it may be, I don't have any problem with cameras in the courtroom. And if you're all as responsible as Greta and I are, then there's no problem with commentators either. But the first thing I would stop would be I would stop the daily spins outside the courthouse. I would stop the microphone down on the first floor so that everybody can get down there, other lawyers can get down there and tell you what happened that day. The witnesses can tell you what happened, the attorneys for the witnesses that can tell you what happened, and I would stop all of that. Now, Greta says, hey, Raj, what about the First Amendment? Well, this is if I ruled the world. And I recognize, obviously, the First Amendment problem. You can't do that. But, oftentimes judges have to make decisions that put different amendments and different parts of our Constitution in the, what's the great legal word, in tension with one another. And so they decide that in this particular instance, this amendment gives way to this amendment. The right to a fair trial perhaps is more important in this set of circumstances than the right to the First Amendment of free speech, that curtailing the ability for lawyers to hold press conferences on the floor, to just walk up to the microphone, to give their spin, may not be as important as perhaps having a camera in the courtroom so that the United States of America and the people around can see what goes on in their courtrooms. I don't have great confidence in good taste by lawyers. And I think that, therefore, you have to impose rules that obviously put you in conflict with the Constitution.
See, and the problem that I have is when you start imposing rules, that's where you get started. You know, that's where you start cutting into the Constitution, when we carve out these sorts of rules. And the bottom line is there is tension between different amendments and different situations. But if we have, for instance, a sequestered jury, and we have a fair trial for both sides, I don't care what the lawyers are saying out front, even if it's untruthful. You know, I'm going to hit the remote. I hope everybody else does, but I just have a horrible fear when we start carving out little rules in different instances, because I look at it in terms of the big picture. And frankly, I don't have that much confidence in the government or in judges in determining what is okay to say when.
Okay, Bernie?
There was something you just said I would like to, if you wouldn't expand on it. You said that early on that without the cameras, fairness is inhibited, can be inhibited. No, you said is inhibited. And then secondly, you said that because of the cameras, the O.J. Simpson trial was one of the few instances where the defendant was on a level playing field. And I've covered at least 100 trials when I was a reporter, and I don't understand what you're saying.
Okay, I don't. If I said that way, I misspoke. I don't know if it's taking sound bites, but I think the cameras are more fair and accurate in reporting than print journalism, because they enable you to make a decision. You don't have to see it through the eyes of someone else, and you don't have to worry about the 600-word columns. You can actually be there and see it. It's more accurate. It's more accurate to watch it yourself than to listen to Roger and me or to read any of these newspapers. So that's what I intended to import. What was your other point? I'm sorry.
Well, I guess it's on.
Yeah.
Oh, level playing.
Level playing field.
Oh,
That's
no,
one of the few instances.
Oh no, this trial, not necessarily because of the cameras. This case was a level playing field. And I've tried criminal cases for 15, 16 years, and I'll tell you that you very rarely have the money to hire your own experts. Most people who get charged with criminal crimes don't have two nickels to rub together. And if you don't have two nickels to rub together, you get a court-appointed lawyer, and if you want a transcript of an hour's worth of testimony, you have to beg some judge. I mean, this is very bizarre that in this particular case, O.J. Simpson, he had an army of lawyers to meet the prosecution's army of lawyers. They both probably had 9 or 10 lawyers at least working on each side. They both had experts. Experts are fabulously expensive. I forgot what Dr. Lee got and what Dr. Baden got. I mean, it was phenomenal. Most cases, defendants don't put up their own medical examiners. They don't have some doctor coming out to the scene. So it was extraordinary in that regard. That's the simple truth. Even if you are middle class in this country, if you have $300,000, you still aren't up to a level playing field in a criminal prosecution when you look at the resources that the prosecution has. And that's what I meant by level playing field. O.J. Simpson had several $1 million to actually fight this like ideally a lawyer would like to fight the case.
Let me also just add this. Let me tell you the reason that the defense wanted the camera in the courtroom. The defense wanted the camera in the courtroom because they felt that with a camera in that courtroom, they had a better chance of getting a fair trial from Judge Ito, because they felt that in some ways his rulings. This is a man who is a career district attorney. His wife is a police officer, and was appointed by an extreme law and order judge to be a governor to be a judge. The defense felt that one of the things that would help them was be a camera in the courtroom, because they felt that by exposing the rulings that might come down, that there would be a pressure on the judge to at least be or think about being more fair than he might have been if there wasn't people watching him. Did the camera in the courtroom make it more fair? I don't know. The defense clearly wanted a camera in the courtroom because they felt it would help them that way.
Okay, does that mean what you're saying and what you have been saying the whole time is that the question maybe of this conversation would be, can an average person get a fair trial?
Oh, well, we'll have that
not.
next year. That's a whole different
That is a more difficult
Is there anybody in
issue.
here that could get a fair trial like that? No.
And it depends. It depends. I mean, it depends what the resources are being put up against you.
Can I ask a quick follow-up right on that?
Okay.
You two have said, and everybody said, Mark Furman was an absolute mistake. Let me ask you, because you both know California, know the cast of characters. How many other cases, speaking of fair trials, did Mark Furman testify against a black person where no one on the defense cross-examined him in any meaningful way whatsoever?
I will guess at that.
Yeah.
I will guess at that.
Yeah.
But I will tell you several.
Absolutely.
Several.
Dozens or hundreds.
Yeah, I mean, I'm not saying dozens, I'm not saying hundreds because I don't know, but I will tell you several, and I mean dozens, 50s, hundreds, I don't know. But I guarantee you this guy got away with it.
And the more troubling issue is how many times did he testify in cases when people knew and looked the other way?
Yeah, of course the LAPD knew. Of course his brother and sister police officers knew about this guy. This guy wasn't a big
In
surprise.
terms of fair justice, I know they knew. It's that the defense teams
Yeah.
didn't have the resources or the concern to bring out the same
and for the same, a lot of people credit the cameras for bringing out a lot of the Mark Furman thing because that's how the McKinney tapes supposedly surfaced. I mean, how would a screenwriter in North Carolina know this trial was going on unless the rest of the world? And by the same token, how would the prosecution have gotten the photos of O.J. Simpson at the football game wearing the gloves that certainly looked like these Aris isotoner gloves? Obviously, it didn't help the prosecution much, but those are, and those are two lucky pieces of evidence for both sides that I think perhaps were related to cameras.
You all should understand how much that evidence was really lost on a California jury. I just moved here from California. I don't own a pair of gloves. Nobody in California owns a pair of gloves. So when they're running around yelling about it's shrunk and this is how it goes on, everybody looked at each other and said, what does this mean? Because none of us own a pair of gloves,
Okay, any questions? Yes.
Greta, you said something that puzzled me about the examples of bad lack of taste.
A bad what?
Lack of taste.
Right.
Excuse me, could you use the microphone so everyone could hear?
Oh, I'm sorry.
Thank you.
If I can get up without knocking Bernie down.
Pardon? Yes, ma'am.
You talked about the problem for the media being using taste in reporting and commenting on courtroom procedures. I agree with you, there was a terrible lack of taste in a lot of reporting on this. The Bobbitt case was unconscionable, the way the commentators were able to snicker to the audience about it.
I couldn't, my mother was watching.
And the double entendres. But you talked about the Marcia Clark hairstyle and the Marcia Clark domestic problems. My recollection is that surfaced because she was accused of misrepresenting her domestic problems to keep Judge Ito from scheduling something on a Friday afternoon that she wanted to put off to Monday, and she used as a reason having to pick up her kids. It was her husband coming up saying, no, that's not true. That's not true at all. That's how that whole thing first surfaced. Then her hairstyle didn't really surface as something tasteless in this. When the reporters all gave her a wolf whistle when she showed up with the new bangs, it surfaced when she filed papers in court to get her ex-husband to increase his stipend to her because she needed to have her hair done more often and buy new clothes because she was on TV every day on the sensational trial. I don't think coverage of those two things, her hairstyle and her domestic problems, was really a lack of taste. I think it surfaced as part of legitimate news coverage.
Well, maybe, and I mean, like I say, I would defend, if you were, the news station and wanted to broadcast that and you hired me, I'd, work like a dog to make sure you could do it. I think you have a First Amendment right to do it. I'm not so sure in the Simpson trial, to me, that was something that if I were making the editorial decision that I would necessarily have done. It's a question of taste, and it's, different people can differ on it, and that's one of the great things about remote controls. I would have fought for your right to do it.
It clearly didn't have anything to do with Simpson's guilt or innocence.
Yeah, any question?
Nor did the fees that the defense was getting
Yes.
have anything to do with it.
Yes.
This guy made a public issue of that during the
That's good.
trial.
I agree.
Yes, Professor Gertz?
I'm puzzled, and neither of you have mentioned one of the things that struck me as most peculiar in the trial. The judge permitted the tapes to be played for the edification of the nation, but only permitted a couple of little snippets to be introduced in evidence. Wasn't that a dreadful thing to indicate a bias? It was just fortunate that somehow or other the jury learned of other aspects of the prejudice from him. But if it had been up to the judge, they would have learned very, very little of it.
Yeah, and I think that was one of the looniest things Ito did. It clearly showed he was playing to the masses. Probably didn't want to appear to be a racist himself. So, I think his decision was wrong in part. There were things in the tape that should have come in. For instance, where Furman brags about planting evidence, I think that was clearly relevant and germane to the issues trial should have come in. There's some things that were on the tapes I didn't think should come in, but I think that was one of Ito's worst days.
Yeah.
Strictly from a purely legal standpoint, he was playing to the masses, and that's the grandstanding that's bad.
Particularly the reason he stated the public was entitled to know. If the public was entitled to know, why wasn't the jury entitled to know?
Yeah, absolutely. I mean, that was one of Ito's, I think, darkest days. And just like, I think the tapes are, I think the tapes in many ways, well, they certainly reveal something horrible with one officer in the LA Police Department. From the letters that I have gotten since the trial for some of my comments from some of my fellow white people, it just shows me that racism is much worse, I think, than I had ever. I mean, I always knew that there was some racism, but you should see the mail that I have received from white America. It would make your hair stand on end. Everyone says, "Oh, I'm not a racist. I'm not a racist." Well, take a look at my mail because there are a lot of them out there.
Yes. Roger, do you have any reaction?
Well, let me just say this. As to the reaction of the verdict, you've heard how I feel about what this case has done in terms of uncovering race. I mentioned to my host last night. There's a writer named Stanley Crouch who is a black writer, and he has a thing called the flip test. And the flip test is what he tries to do is flip it around and take something that is a particularly black experience and put it into a different experience and say, do you think that if it would have been this way, we would have had the reaction that we have? And let me give you a couple of examples. The example he uses is, he used the example of Woody Allen. He said, if Woody Allen was accused of killing Mia Farrow and her boyfriend in New York, and the jury was put in, there was a jury in the jury box, and there were 8 Jews and 4 non-Jews. And the lead cop on the case bragged about what an anti-Semite he was and how he loved to plant evidence on Jews. And the jury came back in 4 hours and acquitted Woody Allen. Would there have been such an uproar as there is over the O.J. Simpson case? And I take this a little different and say, let's, instead of making it Woody Allen and making it Jewish, let's make it Joe Montana, my personal hero, and take it Italians, Chicagoans, and talk about Joe Montana's accused of killing a woman and her boyfriend, and we have a virulent cop up there who's anti-Italian and says, you know what, I love to stick it to those Italians, and I plant it on them every time I can. And we put 8 Italians on the jury, and the 2 hours later when they acquit Joe Montana, which they would under those circumstances, and if I would be there, I would be the first one leading them to acquit my Joe, you would have had none of the reaction that you're having in the O.J. Simpson case. And I bring that to you as something only to think about when you are investigating in the depths of your own heart, your anger that you may feel that this wife beater, and he is a wife beater, and I don't want to be friends with him. I don't want to know this guy. I think this is a terrible man. I don't wish good for him for a lot of reasons. But do I think that there's a bad rap about the fact that he got acquitted and this notion of, oh, well, these black people just took care of him? I think that's wrong, and I think we have to sort of get over that.
And the other thing, too, you can't lose sight of, people who are complaining about the verdict, I bet my right arm didn't watch the entire trial, and I think they're also, when they claim that this was a racist decision, I think they're really ignorant, because I have represented poor blacks in the District of Columbia before all black juries, and I'll tell you, those all black juries have had no problems convicting my black client. And I mean, that happens day in and day out. Blacks convict blacks every day of the week, and don't kid yourself. This was not a racial. This decision was not based on race. This was based on the evidence.
To all of you students who are thinking about being defense lawyers, let me tell you, your worst nightmare is going to be that when you're representing a black defendant and you walk in and see a black judge looking down at you. trust me, on someday you'll remember exactly what I just said. This is an issue that transcends. I mean, there may have been race involved in this case, and we should investigate the verdict, investigate, criticize, look and see what went on, but never lose sight of the fact that there were problems with the prosecution's case. And don't fall into that trap of just saying, oh, you know, the blacks took care of it, because that's wrong.
And don't fall in the trap to say that Johnny Cochran played the race card, because it wasn't playing the race card. Race was a genuine issue in this case, because it was the reason that the defense claimed, whether you believe it or not, it was the reason the defense claimed that Mark Fuhrman planted evidence. Race was just as a germane issue to this case as domestic violence was for the prosecution. Both was motivation evidence.
Yes. Right there. Could you please identify yourself?
Yes, my name is Johnny Conomo, and I'll be sworn in next week.
Congratulations.
Sworn into what?
Illinois.
As a witness?
The Honorable Bar of the State of Illinois. I wanted to direct the panelist's attention to a upcoming trial that won't have cameras, but should be getting media attention, maybe won't get as much, and that's the Oklahoma City bombing trial. I don't think that Timothy McVeigh can get a fair trial. The media has already portrayed him as a villain. We've had all this disaster coverage. To draw an analogy to Mr. Cossack's beloved figure, it's the victims and the city of Oklahoma City. And 2 months ago, we had a report from a retired Air Force four-star general who came out with demolitions explosive expert that came out with some report that was delivered to 39 members of Congress, which draws serious doubts as to whether that bomb could have done the damage, which he says it couldn't have, and pointing toward explosives planted on the pillars. And we didn't hear a whisper about it in the media. And I'm just asking the panelists, why does the media go to Lorena Bobbitt and not Waco? And why does the media not go, and what do you think is going to happen with Oklahoma City? And do you think it's being covered fairly?
Well, first of all, I agree with you. Why does I think it's astounding that the media would pay more attention to Lorena Bobbitt than to Waco as well. And don't start me on that one, because I'll start in on that one. And Janet Reno, who she can commit that horrible mistake and just say she's sorry. For the rest of us, we back over someone in a car, we go to jail for manslaughter. But anyway, I won't get started on that one.
Not a bad one.
Not a bad one. No, not a bad one. But
don't start her on this one.
Don't start me, right.
Do me, trust me on this one.
I don't know what's wrong with just cutting the power in the water and waiting. But anyway, the thing with, can Timothy McVeigh get a fair trial? Yes, he can. Can he get it in Oklahoma where people know people who know people who know people who were hurt? No. Do the federal rules allow for a transfer to a jurisdiction where we have a relatively dispassionate group of citizens who can evaluate the evidence? Yes. Will that be done? I don't know.
Well, they've already moved this case to Lawton, Oklahoma. I don't know how much good that's going to do. Let me tell you what my thoughts are on this. First of all, this will, when it begins to get tried, will become big news. And second of all, there are marvelous lawyers, defense lawyers on this case. The fellow that represents McNichols, Michael Tiger, is an old faculty mate of mine from UCLA, and he's one of the more brilliant trial lawyers you have ever seen in your life, and he is sensational. So there will be incredibly good defense work done in this case. Hopefully, and we're not sure yet, but we're hoping that Greta and I, will be sent down there for at least a week or two to do our show.
Because we'd like to party in Oklahoma, right?
Yeah, that's right. There will be at least a week or two, and usually that good time of the year, February in Lawton, Oklahoma. They write love songs about it's love in Lawton, Oklahoma in February. But we're hoping that we get sent down there for a week or two and are able to do our show from there. Can he get a fair trial in Lawton, Oklahoma? I'm not so sure. Do I think they should have moved this case someplace else? Most likely. Why the press? Let me give you my 1 minute, if I can, my 1 minute story of the press. There's two amendments to the Bill of Rights which allow and guarantee people to make a profit in a capitalistic country. One, of course, is freedom of the press. But the press isn't free. In the sense that you got to buy the press. If you want to watch the news on television, you have to watch those commercials. You want to watch Burden of Proof? You know, you got to watch John Denver singing Rocky Mountain High on CNN. You know, if you want to buy the newspaper, you got to look at the ads and put whatever the 35 cents is. So you get the news, but the news isn't free to us. And then what happens, of course, is that the minute somebody comes along and says, well, wait a minute, you know, Mr. Media, Mr. Press, you're not acting very responsible. We in the press, hey, just a minute. We put our hands over our hearts and we say, freedom of the press, pal, don't be messing around with me. We get to talk about what Paula Barbieri said, because in reality, while it's not very important, it's going to sell a hell of a lot of newspapers or get a lot of people to watch us on television. The other amendment is the Second Amendment. That allows people to sell guns, right? And that allows gun dealers to sell us all the guns we want. And the minute we say, wait a minute, why do you really need this AR-47? I mean, what do you use one of these things for except to kill each other? You put your hand over your heart and say, hey, just a minute. Second Amendment allows us to have these weapons. So there's two amendments which will allow people to make profits under the United States of America. One is the Second Amendment and one is the First Amendment. So if you're making a profit, you go where the profit is. And, you know, there may not be too much money in Waco, a lot of money in OJ, may not be a heck of a lot of money in Oklahoma City, but we think there is, and we think we'll probably get there.
Yes, way back there in the corner. Yes, please.
Okay. My name is Christopher Coale. I'm a first-year student here at the law school, and I haven't had constitutional law yet, so I'm going to need you to bear with me here for a second.
Roger has neither, though.
And this is directed to both of you, but more specifically to you, Ms. Van Susteren. You said something that kind of disturbed me, that there's either proposed there's either proposed legislation or there's something on the books right now in California that's questioning unanimous vote juries.
In criminal cases.
In criminal
currently
cases.
in civil cases.
Okay. Now, like I said, I don't know much about criminal law. No, I do know something about criminal law, but I don't know much about constitutional law. I don't know if that has constitutional implications. But if you're going to defend having cameras in the courtroom, with the media having such dramatic consequences on knee-jerk reactions like you brought up, isn't it, I mean, don't you see a connection there? Don't you see people saying, okay, there's something wrong with the Constitution, then we need to go and change it? I mean, because if this is a serious consideration, I think that the effects in criminal law are going to be pretty severe. That a lot of innocent people could be sentenced to prison because as a result of the OJ case, as a result of having it crammed down our throats for the last year and a half. I mean, I lost interest after the first 2 months. That people are saying, okay, look, it doesn't work. We saw it for ourselves. And they may not have seen the direct camera coverage, but they saw CNN. You know, they watched either of you two, and I'm not saying you put a spin on it, but there were a lot of other people that did in the media that aren't responsible, that don't exercise tact. I don't think we can just hold up the Constitution and say, hey, you know, this is our sacred doctrine. No, because it's down the line, it's going to come back.
Chris, you're a very brave young man asking Greta that question, because one of her pet loves in this life is the Constitution, and what you're suggesting perhaps is a little bit of a change in the Constitution, which I will now tell you she does not favor. Having said that, and trying to give you a chance to get out of the room, which you haven't taken yet, go ahead, Greta, answer.
Well, let me clarify that just real quick. I'm not suggesting a change in the Constitution. I mean, from what I know about it, which isn't much, I think it's a good idea, and I believe in it.
Is that your understanding, Greta, that the Constitution requires cameras in the courtroom?
No. The Constitution does not say explicitly cameras can be in the courtroom. It talks about freedom of the press. And it was written at a time, obviously, we don't have cameras. But cameras, in my opinion, I'm not talking about the commentary that goes with it, the color commentary, which is what Roger and I do. But cameras in a pure form, sitting in the courtroom, give the reader, viewer, whatever you want to call it, the observer, the clearest picture of what happened without having to filter it through someone else's interpretation, which you do when you listen to our color commentary or you read a newspaper.
Let me just say this. What you're suggesting is that I suppose is that because of what people saw in the Simpson case, there's going to be a backlash and we're going to have harsher criminal laws and more innocent people might get convicted.
I'm suggesting that as a future lawyer, I'm not satisfied to just hold up the Constitution and say, you know, I'm going to walk away from this because we can't mess with it. I think it's the potential for abuse is so large.
With what? With the
media.
You know what? I agree. That's why I keep going back to this, harping on this thing about responsibility and where do you draw the line. And I don't have any bright yellow line test, but the media is extraordinarily powerful, and I hadn't realized the magnitude of its power until O.J. Simpson. But the media is here, and it's here to stay. And I think it's always better to have more information than less information. But how do we police ourselves? And the bar, interesting enough, the bar has the bar council to police. Journalists don't have a journalist council. We don't have any group. We don't have any I've never seen any code for us. Have you, Roger?
No.
We are relatively unregulated. And the best thing about us though is that we love to get each other. And if nothing else, if you hear someone else on another network says something that's really off the wall, everybody jumps on it and says, listen to what NBC is doing. So it's sort of dog eat dog in that respect.
Chris,
but,
I'm sorry.
No, go ahead, Roger.
I was going to say, Chris, the problem is just what I just said. One of the things is that when the media is a profit-making organization, and there's shareholders who at the end of the year want to see the annual report that says how much money did Gannett make and how much money the Chicago Tribune or whatever it is, how much money they make. And therefore, the level is to sell the most newspapers, to sell the most ads. And so the idea of self-policing is something that, while sounding nice, is something I don't see happening. And that's why, horrible as it sounds, I favor some kind of legislation to prohibit certain activities of the media. Please forgive me, because I see this as a major problem, and I see what's going to happen is that unless we police ourselves, there could be a real backlash.
Except that the policing oftentimes does go in our effort to make the other guy look bad in the media. I mean, that is one sort of self-policing mechanism, and we do have the ability to jump all over each other. But it's like asking the police to be responsible for the police. Which I've asked that the LAPD would be responsible for each other in light of the Mark Furman, and I think the bar has to do that with lawyers, and I think the journalists do it with journalists. But as Roger says, I'm oftentimes very naive, and I expect everyone to be responsible.
I never said naive. Did I?
Well,
say
you
naive?
said that I put a nice spin on it.
Well, due to tight airline schedules, we're going to have to bring this to a close. One of my colleagues who couldn't make it today said, "I really regret not coming. I felt that." Greta and Roger were like friends over the time of the trial. And I think after today, I think we all share her feeling. And we appreciate your coming today. I want to thank Doris Long and Alberto Bernabe, colleagues of mine. Stand up, please.
Yes.
Who are very helpful in putting this together. And I want to thank the whole staff of John Marshall Law School and the students who have helped make this program a success today, and certainly you for attending.
And
Thank you very much.
Let us thank you on behalf of Greta and myself. This is a
And
real
stay
thrill for
tuned
us.
to Burden of Proof. And if you have to go out, just leave your TVs on if you're one of those Nielsen houses.
Yeah. Thank you very much. Thank you.
Thanks a lot. Appreciate it.
Thank you.